Imagine cruising down a California highway in 2026 only to face unexpected fines, stricter enforcement, or major changes to how you buy a car or ride an e-bike, all hitting millions of drivers at once. From expanded move-over rules that demand instant action on every stopped vehicle with hazards flashing, to tougher DUI consequences that stretch probation for years, and new protections against dealership scams that could save you thousands, these 10 game-changing laws reshape daily driving. Stay ahead, avoid costly surprises, and keep your license clean. Here's exactly what's coming and how to prepare.
Number 1. Expanded Slow Down and Move Over Law, AB 390. California drivers now face a broader slow down and move over requirement under AB 390, effective January 1, 2026. This law expands protections beyond just emergency vehicles with flashing lights, tow trucks, and marked highway maintenance crews. It now covers any stationary vehicle displaying flashing hazard lights or other warning devices, such as cones, flares, or retroreflective markers. When approaching such a vehicle on a highway or roadway, drivers must first attempt to change lanes to provide a buffer if safe and possible, or significantly reduce speed while maintaining control. The goal is to prevent tragic accidents where roadside workers, stranded motorists, or helpers get struck by passing traffic. Picture yourself cruising on a busy freeway and spotting a car pulled over with hazards blinking. This rule demands immediate action to create space, reducing the risk of secondary collisions that claim lives every year. Enforcement focuses on high-risk areas like shoulders and work zones, where CHP officers prioritize unsafe behaviors like failing to slow or weave through setups. Violators risk citations with fines that can add up quickly, plus points on their license that affect insurance rates. The change addresses real-world scenarios where drivers previously ignored non-emergency stopped vehicles, leading to preventable harm. Studies from highway safety organizations show that proper lane changes or speed reductions cut incident rates dramatically in these situations. For everyday commuters, this means scanning ahead more carefully, especially during commutes when breakdowns or flat tires are common. Imagine merging lanes smoothly to pass a disabled SUV with hazards on. It's a small adjustment that saves lives. Local agencies may post additional signage to remind drivers, but the responsibility falls on everyone behind the wheel. Practical steps include practicing defensive driving habits, check mirrors early, signal lane changes promptly, and slow to a safe speed if merging is infeasible. Parents teaching teens or rideshare drivers can emphasize this as a core safety habit to build awareness from the start. This update promotes a culture of shared responsibility on California's roads, where one driver's caution protects many. By complying, you avoid hefty penalties and contribute to fewer roadside tragedies. Stay alert, plan your moves, and treat every flashing light as a signal to act responsibly. Your vigilance makes the difference between a routine drive and a potential disaster.
Number 2. Stricter DUI penalties and extended probation, AB 1087. California introduces tougher consequences for vehicular manslaughter while intoxicated under AB 1087. This bill increases the probation term from 2 years to a range of 3 to 5 years for convictions of vehicular manslaughter or gross vehicular manslaughter while intoxicated. The change targets drivers who cause fatal crashes due to alcohol or drugs, allowing courts more time to enforce supervision, rehabilitation programs, mandatory treatment, and monitoring to prevent repeat offenses. Imagine a tragic scene where impaired driving leads to loss of life. The extended probation ensures longer accountability, giving judges flexibility to tailor sentences based on severity while prioritizing public safety. Penalties remain severe, often including prison time, hefty fines, and license revocation, but the longer probation period adds layers of oversight, like regular check-ins and sobriety requirements. This addresses gaps where short probation allowed some offenders to slip back into dangerous habits too soon. Research from highway safety groups in prior DUI studies shows extended supervision significantly reduces recidivism in alcohol-related fatalities as it combines punishment with structured recovery support. For California drivers, this serves as a stark reminder of the life-altering risks of impaired driving, whether from a night out or a misjudged decision. Picture yourself at a gathering, deciding whether to drive after drinking. This law underscores that one poor choice can lead to years of legal consequences beyond initial sentencing. Practical compliance starts with zero tolerance. Designate a sober driver, use ride shares, or plan ahead to avoid any alcohol if you'll be behind the wheel. Community programs and apps for breath testing can help reinforce safe habits, while families discussing these risks can build awareness among younger drivers prone to impulsive choices. Ultimately, AB 1087 strengthens deterrence against one of the most preventable causes of road deaths, fostering safer highways for everyone. By extending probation, the state emphasizes rehabilitation over mere punishment, aiming to break cycles of impaired driving. Drivers benefit from clearer boundaries on consequences, encouraging responsible choices that protect lives and avoid devastating legal outcomes. Number 3. Ignition Interlock Device Program Extension, AB 366. California extends its Ignition Interlock Device Program under AB 366, effective January 1, 2026, making mandatory installation longer and more consistent for many DUI offenders. Previously, some first-time or lower-level DUI convictions required an IID for as little as 6 months, but this bill aligns requirements more stringently, often mandating devices for 1 to 3 years, depending on the offense severity, prior convictions, or blood alcohol concentration levels. The IID prevents the vehicle from starting if alcohol is detected on the driver's breath, acting as a technological safeguard against repeat impaired driving. Visualize a driver who once made a dangerous choice, now required to blow into a device every time they start their car. This extension ensures accountability lingers well beyond the initial court date, reducing the chance of future incidents. Courts can impose stricter terms for repeat offenders, including extended monitoring periods and additional fees for device maintenance and calibration. Data from national traffic safety studies demonstrate that IID programs cut recidivism rates by up to 67% during the installation period, with benefits carrying over even after removal as habits improve. For California motorists, this change reinforces that DUI consequences are not temporary. They reshape daily routines and encourage lasting behavioral shifts. Think about a commuter who relies on their car for work. Facing an IID means planning around calibration appointments and avoiding any alcohol consumption that could trigger a lockout. Practical steps include understanding your specific sentence details from the DMV, budgeting for installation costs, often $70 to $150 monthly plus setup fees, and treating the device as a reminder rather than a punishment. Families can use this as a teaching moment, discussing how one impaired decision impacts freedom and finances long-term. By prolonging the IID requirement, AB 366 strengthens prevention efforts on roads where impaired driving remains a leading killer. It balances enforcement with rehabilitation, giving drivers tools to stay sober while protecting others. Compliance turns a restrictive measure into a pathway for safer choices, ultimately benefiting communities through fewer alcohol-related crashes and tragedies. Number 4. Automated Red Light Enforcement Expansion, SB 720. California significantly expands automated red light enforcement through SB 720, effective January 1, 2026, allowing more cities and counties to install and operate red light cameras at high-risk intersections without prior local voter approval in many cases. The bill streamlines the process for jurisdictions to deploy these systems, focusing on locations with frequent collisions, pedestrian injuries, or proven violation patterns. Cameras capture images of vehicles entering intersections after the light turns red, issuing citations with photographic evidence of the violation, license plate, and timestamp. This expansion aims to deter dangerous behaviors like running reds, which contribute to thousands of crashes annually across the state. Envision approaching a busy urban intersection during rush hour. This law means cameras could now monitor more spots, sending mailed notices with fines typically ranging from $100 to $500, plus potential points on your driving record if contested unsuccessfully. Safety research consistently shows that red light cameras reduce right-angle crashes by 20 to 40% at equipped intersections, with spillover benefits to nearby areas as driver awareness increases. For everyday California drivers, the change heightens the need for full stops behind the limit line, especially in familiar neighborhoods where cameras might suddenly appear. Picture hesitating at a yellow light and deciding to push through. The risk now includes not just immediate danger, but also an automated ticket arriving weeks later, impacting insurance premiums. Practical habits include treating yellows as caution signals, practicing the 3-second rule after stopping, and staying vigilant for new signage announcing camera zones. Commuters in expanding cities like Los Angeles or San Diego should check local government websites for updated camera locations to avoid surprises. SB 720 promotes proactive enforcement to make intersections safer without relying solely on officer presence, addressing resource limitations in busy areas. While some debate privacy or revenue concerns, the core focus remains collision prevention. By adapting to stricter automated oversight, drivers foster habits that protect vulnerable road users like pedestrians and cyclists, turning potential fines into opportunities for safer, more attentive driving overall.
Number 5. Autonomous Vehicle Marker Lamps and Communication Requirements. SB 480 and AB 1777. California advances autonomous vehicle safety standards with SB 480 and AB 1777, both taking effect January 1, 2026, mandating specific visual and communication features for self-driving cars operating on public roads. These bills require AVs to display distinctive marker lamps, such as amber or white pulsing lights visible from multiple angles when in autonomous mode, clearly signaling to human drivers, pedestrians, and cyclists that no one is actively controlling the vehicle. Additionally, AVs must incorporate external communication systems like digital displays or audible signals to convey intentions such as yielding, stopping, or turning in complex scenarios. This helps reduce confusion in mixed traffic environments where traditional cues like eye contact or hand signals from a driver are absent. Imagine encountering a driverless car approaching a crosswalk. The new lights and signals provide instant, unambiguous information, preventing hesitation or misjudged maneuvers that could lead to collisions. Practical tips include familiarizing yourself with common AV indicators through manufacturer videos or DMV resources, maintaining extra following distance in AV-heavy areas, and reporting any confusing encounters to local authorities for refinement. Rideshare users or delivery recipients in pilot zones should note these signals as part of everyday navigation. SB 480 and AB 1777 pave the way for safer integration of autonomous technology by prioritizing transparency and predictability. These requirements balance innovation with public trust, ensuring AVs don't introduce new hazards. Drivers who stay informed and observant help foster an environment where human and machine drivers coexist effectively, ultimately contributing to fewer crashes and smoother traffic flow across the state.
Number 6. Prohibitions on license plate obstructions and alterations. AB 984. California cracks down harder on license plate obstructions and alterations starting January 1, 2026, under AB 984, imposing a $1,000 fine for violations that make plates difficult to read or identify. The law explicitly bans any coverings, frames, coatings, tints, or modifications that obscure letters, numbers, registration stickers, or reflective surfaces, even if partially. Common issues like decorative frames that cover edges, mud splatter left uncleaned, or illegal plate covers with slogans now trigger immediate citations during traffic stops or automated camera enforcement. This targets practices that hinder law enforcement, toll collection, and red light cameras from capturing clear images. Envision pulling up to a stoplight with a stylish frame slightly overlapping your plate. The officer or camera could flag it instantly, leading to a steep penalty on top of any underlying violation. Enforcement data and safety reports highlight how obscured plates complicate hit-and-run investigations and contribute to evasion in traffic crimes, justifying the elevated fine to promote compliance. For everyday drivers, this serves as a wake-up call to inspect plates regularly, especially after off-road trips, rain, or car washes. Picture discovering your temporary tag curling at the edges or a bug-splattered rear plate. This rule demands proactive cleaning and removal of any add-ons that risk obstruction. Practical steps include using plain, transparent frames only, if any, checking monthly for dirt buildup, and avoiding online-purchased vanity covers marketed as legal but often borderline. Vehicle owners in urban areas with frequent plate readers should prioritize visibility to dodge surprise tickets that hit insurance rates and add administrative hassle. AB 984 reinforces accountability by ensuring plates remain fully legible at all times, supporting efficient traffic management and crime prevention. The higher fine acts as a strong deterrent, shifting focus from minor aesthetics to genuine road safety and identification needs. Drivers who maintain clear, unaltered plates avoid costly surprises and contribute to smoother enforcement for everyone sharing California's highways. Simple vigilance turns potential fines into peace of mind on every drive.
Number 7. Electric Bicycle and Device Safety Standards, SB 1271. California tightens regulations for electric bicycles, e-bikes, and similar low-speed electric devices under SB 1271, effective January 1, 2026, introducing stricter safety equipment and usage rules to protect riders and motorists alike. The bill requires all e-bikes, classified as Class 1, 2, or 3, to be equipped with functional headlights, taillights, reflectors, and brakes capable of stopping within specified distances, with mandatory compliance during low light conditions or poor visibility. Riders under 18 must wear approved helmets, and the law prohibits modifications that increase motor power beyond legal limits, 750 watts max, or remove speed governors. Violations can result in citations, fines up to several $100s, or even impoundment for unsafe or altered devices. Picture zipping through a crowded bike lane on an e-bike without proper lights at dusk. This rule demands visible signaling to prevent collisions with turning vehicles or pedestrians who might not anticipate your speed. Safety analyses from transportation agencies show that enhanced lighting and braking requirements reduce nighttime crash risks for e-bike users by improving detectability, especially in urban areas with heavy mixed traffic. For California commuters relying on e-bikes for eco-friendly travel or last-mile connections, the change emphasizes preparation. Check equipment before every ride, carry spare bulbs or batteries, and avoid cheap aftermarket parts that compromise standards. Imagine navigating a busy trail or city street. Proper lights make you predictable to drivers, while strong brakes give control in sudden stops. Parents purchasing e-bikes for teens should verify class compliance, helmet fit, and light functionality to instill safe habits early. Local bike shops often offer inspection services to ensure alignment with the new standards. SB 1271 promotes responsible e-mobility by closing loopholes that allowed under-equipped or overpowered devices on shared paths and roads. These measures balance the growing popularity of electric-assisted cycling with public safety priorities. Riders who adopt the required gear and practices not only avoid penalties but also contribute to fewer incidents, making streets safer for all users, from pedestrians to traditional cyclists and motorists. Staying compliant turns e-bikes into reliable, visible partners in sustainable transportation across the state.
Number 8. Off-highway electric motorcycles, e-motos, regulations SB 586. California introduces comprehensive rules for off-highway electric motorcycles, commonly called e-motos, under SB 586, effective January 1, 2026, clarifying their legal status and operational limits on public lands and trails. These battery-powered two-wheelers, often resembling dirt bikes but without traditional engines, must now meet specific equipment standards, including functional brakes, headlights, taillights, mirrors if used on roads, and speedometers if exceeding certain classes. The bill prohibits unregistered e-motos from operating on highways or streets unless they qualify as street-legal electric motorcycles with DME registration, plates, and insurance. On designated off-highway vehicle areas, OHV, riders face new restrictions: no operation in non-motorized zones, mandatory helmets for all ages, and bans on high-speed models in sensitive ecological areas. Fines for non-compliance can reach hundreds of dollars, with possible confiscation for repeated or egregious violations. Visualize tearing up a desert trail on an e-moto. This law ensures you stay within permitted zones and equipped properly to avoid citations from patrolling rangers. Environmental and recreation studies underscore the need for these regulations, as unregulated e-motos contribute to trail erosion, wildlife disturbance, and conflicts with hikers or equestrians in shared spaces. For enthusiasts in California's vast OHV parks like Hollister Hills or Carnegie, the change means double-checking registration status and gear before heading out. Picture loading your e-moto for a weekend ride. Verify lights work, carry proof of compliance, and stick to marked trails to respect noise and impact limits that preserve access for future users. Families introducing kids to off-roading should prioritize models designed for youth with speed governors and ensure adult supervision aligns with helmet and zoning rules. Local OHV clubs often host compliance workshops to help riders adapt smoothly. SB 586 strikes a balance between promoting electric recreation and protecting public lands from overuse. By defining clear boundaries for e-motos, the state prevents misuse while encouraging responsible enjoyment of off-road spaces. Riders who follow the equipment, registration, and area-specific guidelines enjoy thrilling rides without legal interruptions, supporting sustainable access and fewer enforcement encounters across California.
Number 9. Duplicate driver's license for address changes, SB 506. California simplifies the process for updating addresses on driver's licenses with SB 506, effective January 1, 2026, allowing eligible drivers to obtain a duplicate license featuring the new address without always requiring an in-person visit or full renewal. Under the updated rules, if your license is still valid and the change is solely for address correction, you can apply online through the DMV portal or by mail for a duplicate card that reflects your current residence. This applies to most standard Class C licenses, provided no other changes like name, medical conditions, or endorsements are involved. The fee remains comparable to a standard duplicate, around $35 to $40, but the convenience reduces wait times and eliminates unnecessary trips to field offices. Picture moving to a new apartment across town and needing proof of residency for voting, banking, or employment. This streamlined option lets you update your official ID quickly from home, avoiding long DMV lines and keeping your records current without delay. DMV efficiency reports and user feedback indicate that easier address updates improve compliance with the legal requirement to notify the department within 10 days of a move, reducing outdated records that complicate traffic stops or identity verification. For California's mobile population, students, job relocators, or families shifting neighborhoods, this change offers practical relief. Imagine receiving a traffic ticket or insurance quote with an old address. A quick duplicate request ensures everything matches reality. Steps to implement include logging into your DMV online account, uploading proof of new address, utility bill, lease, etc., paying the fee, and choosing mail delivery for the new card. Keep your old license until the duplicate arrives, then destroy it to prevent misuse. Those without online access can still mail Form DL-44 or visit in person if preferred. SB 506 modernizes a routine but essential task, making it faster and less burdensome while maintaining security standards. Accurate address information supports everything from emergency notifications to fair insurance pricing. Drivers who take advantage of this option stay compliant effortlessly, avoid potential fines for failing to update within the deadline, and maintain seamless access to services tied to their license. Proactive updates turn a minor chore into a simple step for organized, stress-free driving life in a dynamic state.
Number 10. California Combating Auto Retail Scams, CARS Act, SB 766. California launches the Combating Auto Retail Scams Act under SB 766, effective October 1, 2026, to shield consumers from deceptive practices during vehicle purchases and financing. The law prohibits dealerships from engaging in yo-yo financing, where a buyer drives off with a car only to be called back later with worse loan terms, by requiring full disclosure and written commitment to the agreed financing before the sale finalizes. It also bans hidden fees disguised as mandatory add-ons, mandates clear itemization of all charges on contracts, and strengthens penalties for bait-and-switch tactics or falsified credit information. Dealerships now must provide buyers with a one-page summary of key terms in plain language, including total cost, interest rate, and any conditions. Picture walking into a lot excited about a new car, signing papers, and later discovering unexpected markups or rate hikes. This act closes those loopholes, giving buyers stronger leverage and transparency from the start. Consumer protection studies and complaint data from the California Department of Justice reveal that auto retail scams cost buyers millions annually through pressured upsells and post-sale financing switches, often hitting first-time or low-credit buyers hardest. For California drivers shopping for new or used vehicles, the change promotes informed decisions. Review every line of the contract, ask for the one-page summary up front, and walk away if anything feels unclear or pressured. Imagine negotiating a deal. Insist on seeing the final out-the-door price in writing before handing over a deposit, and verify financing approval matches what was promised. Use online tools or third-party calculators to cross-check rates, and bring a trusted friend or family member to spot red flags during long showroom sessions. SB 766 empowers consumers by enforcing accountability in an industry prone to high-pressure sales, reducing financial surprises that lead to debt traps or repossessions. With clearer rules and harsher consequences for violations, including fines and license revocation threats, the law levels the playing field. Shoppers who stay vigilant and demand transparency protect their wallets and drive away confidently, knowing the deal is fair and final. Embracing these protections turns car buying from a stressful gamble into a straightforward, trustworthy process across California's dealerships. California's 2026 driving laws mark a major shift towards safer, fairer, and more accountable roads for millions. From the expanded slow down and move over rule that protects every stranded driver, to tougher DUI probation and longer ignition interlock periods that curb repeat tragedies, these changes tackle real dangers head-on. New red light cameras, clearer autonomous vehicle signals, strict plate visibility rules, upgraded e-bike standards, regulated e-motos, easier address updates, and powerful anti-scam protections in car buying all work together to reduce crashes, prevent deception, and keep everyday drivers informed and prepared. Staying compliant isn't just about avoiding fines, it's about protecting lives, saving money, and contributing to smoother, more predictable highways across the state. These updates reflect a commitment to modern safety and consumer rights in a fast-changing world. Like this video if it helped you stay ahead of the changes, subscribe for more California road law updates, and drop a comment below. Which of these 10 rules surprised you the most? Share your thoughts, we read every one. Check out our related videos on safe driving tips and DMV hacks next.